You are Juan Jose Serna. Mr. Serna, you now stand charged yet again.
Here we go again, burglary of a motor vehicle. And yes, you heard that right. Again. In Texas. This is no small potato crime. It's a serious offense. That can stack up faster than unpaid parking tickets.
I spoke to two witnesses who viewed the incident. The first witness stated that the suspect's motor vehicle pulled up the complaining witness's motor vehicle, and the suspect wearing a camouflage hoodie got out and pulled on a door handle of the complaining witness's motor vehicle, attempting to open it. That set off the alarm of the motor vehicle, and the first witness advised that the suspect got back into a car, drove off to another area of the parking lot, parked and waited for the alarm to stop alerting. The first witness stated that once the alarm stopped making noise, the suspect jumped back over to the complaining witness motor vehicle, parked.
So, just to be clear, this wasn't a quick smash and grab. This was a patient, two-step break-in. Park, wait, return, like a criminal version of Groundhog Day.
Jumped out of a motor vehicle, got into the passenger side of a waiting vehicle with an unreadable plate, and everybody was then heard the male tell the driver, "Go, go, go." Another law enforcement officer advised he was patrolling when the gold Tahoe that the suspect was observed in passed him at a high rate of speed. Traffic stop was initiated, and the law enforcement officer was able to send pictures from the witness showing the suspect motor vehicle leaving the location to another law enforcement officer who was able to verify the suspect motor vehicle. After further investigation and search of the suspect, a camo jacket was found in the rear seat, and a flat-pointed screwdriver consistent with the tool that would be used to break a lock on the complaining witness's door.
It was both that were attempting to B&B.
Yes, Your Honor. The defendant is the registered owner of the vehicle, but the motor vehicle was displaying a counterfeit tag that did not come back registered to
So Mr. Serna is the one that owns the Tahoe?
No, I apologize, Your Honor. Mr.
The other
Stern is
gentleman.
the second. Looks like the second individual that was in the passenger, that was in the driver's seat whenever the complaining witness came out of the vehicle, is not the owner of the vehicle.
Judge, if I may, the complainant or the witness stated that she saw a Hispanic male with a camouflage hoodie. When they were pulled over, there's two people in the vehicle. The camouflage hoodie was not on my client, so I'm saying that there's no probable
They have
cause.
both of them in the car, being car.
The both of them in the car.
That's what, according to you, right?
Yes, Your Honor.
Both individuals.
We're in the car attempting to,
I have the,
Because I thought it read that one person wearing a camouflage hoodie was in the car. when
that was the
somebody-
second one. So the first person goes in, gets out, and then that's when the other one goes in. And then at that point, the complaining witness comes up and tells them to take off.
And now, the rap sheet. Brace yourself, because this isn't just a list of mistakes. It's a greatest hits album of bad decisions. How many charges do you think he's racked up? Guess in the comments.
Assault of a family member, attempted burglary of a motor vehicle, burglary of a motor vehicle, theft, third, burglary of a motor vehicle, unauthorized use of a motor vehicle, evading arrest in a motor vehicle, burglary of a motor vehicle, assault, possession of marijuana, robbery, felony theft, assault, a prior, now a felony, another felony assault, unauthorized use of a motor vehicle, tampering with a government record, felony theft, unauthorized use of a motor vehicle, and now open, you have unauthorized use of a motor vehicle, felony theft, burglary of a motor vehicle, and possession of a criminal. What on earth do we need to do to keep our county safe? It's a rhetorical question, but I don't know what on earth we need to do to ensure that our county and our cars are safe. You live in Houston, dude. You don't live in Montana or Wyoming.
The judge isn't sugarcoating it. This is Texas, and people guard their cars like treasure chests. Mess with the wrong one, and you might not live to tell the tale.
Time after time.
Judge, he's due in felony court tomorrow for his felonies. His bond is currently set at 10,000 for this misdemeanor. Can we reset till Friday to see what happens in felony? I'm asking the court to not revoke his bond. His bond is set at 10,000. I'm asking the court to just keep it in place.
So there's nothing for me to revoke because he has not made bond on
In
the
felony, correct.
You're now being held at no bond on at least 2 of the felony cases that I see. If, I don't know if you're going to get out, but if you do, I'm ordering you to have home confinement. I don't want you out at all because you scare me, Mr. Cerner. You really do. You're not going to be in possession of weapons. On your other ankle, I'm going to put a scram monitor so I know that you're not consuming alcohol. I don't want you using any dope. And let me be frank. If I find that you break any of these conditions on your bond, I'm going to make your bond so high you'll have teeth popping out. Do you understand? Do we have, who got the co-defendant? Do we have the co-defendant? No contact with the co-defendant, please, Felicia.
Still loading, Your Honor, I apologize. We have the co-defendant, Your Honor.
Say it again.
We have the co-defendant. I'll sit on the protein.
Let me ask you this. You ever had a job before? Like a full-time job?
Yeah.
That's probably a good idea. When you have too much time on your hands, you become self-destructive. So with this, it's just a matter of time, dude. It's either dead or 50 years, man. Really? Life's too short to live in a 6x9 box for the next 50 years. All right. Good morning, man.
Hi.
Just a little bit down so I can see your eyes.
Sure.
That's okay. How are you? Ma'am, you've now picked up another case. You're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you.
Judge, if I could just confirm the name.
Agbacielo.
On April 1st, 2025, a law enforcement officer was dispatched to a residence in Harris County, Texas regarding a disturbance. Law enforcement officer made contact with the second complaining witness who stated that he was inside the apartment when he heard the first complaining witness outside getting yelled at by the defendant. The second complaining witness went outside to see what was going on, and the defendant yelled at him to stop putting things in the pothole in the parking lot. The second complaining witness told the defendant he was fixing the hole. And the defendant then threatened both the complaining witnesses, pointing at them with their fingers, making a pistol shape with their fingers, saying, "I'm going to shoot you."
Wait, you said there were 2 complaining witnesses.
Yes, Your Honor.
Okay.
That's what I have here. It says, "I'm going to shoot you," towards both complaining witnesses.
And we have Ms. Agbacielo making the alleged threats.
Correct, Your Honor.
Your Honor, there's only charges one.
There's only, yeah,
All right.
yes, Your Honor.
Okay, who is the complaining witness?
Video strong.
Is it a known person? Because we have priors with Ms. Agbacielo and there are assaultive and, pretty dangerous priors. Any of the same complaining witnesses?
Does not appear so, Your Honor. I'm looking through. No, Your Honor. It seemed like it's just, from what we can see, it's.
Was it a street worker? Was it someone working for the city or
It's someone that lives there, Your Honor.
just out there fixing the potholes?
That's correct, Your Honor.
Okay. All right, Ms. Agbacielo, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. Do you understand, ma'am?
Yes, Your Honor.
Okay. Do you have the ability to hire a lawyer, ma'am?
Yes, Your Honor.
Okay, we can give you time. So what I'll have you do now is I'll have you sign a receipt of victory while you take a seat, while we draft the bond conditions, I'll have you sign it, and after that, you'll be free to go.
Yes, Your Honor.
Please, ma'am, don't pick up any new cases. Just don't have contact with these people. I don't want to have to put you in jail, you know?
Your Honor, it was the same thing the last time, the
Just,
last case.
just please be careful, you know?
Yeah.
Really.
People make false allegations all the
And
time.
I get it. There's always two sides to the story. That's why you have a lawyer. That's why we'll give you time. The evidence will point to whose side is correct.
Yeah, and I
you
do
know.
have them.
So, please.
Thank you.
Yes, ma'am.
All right, good morning, Mr. Kyles. Sir, you're charged with deadly conduct. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On April 2nd, 2025, in Harris County, Texas, a law enforcement officer was dispatched from an apartment complex and spoke to complaining witness who said that she was laying in her bed and was woken by her son, the defendant, screaming. And then she heard 2 gunshots go off in the apartment. Complaining witness then got out of bed and took the gun from the defendant, hid it, and called 911. Upon arrival, the law enforcement officer recovered the weapon, along with 2 fired shell casings and 2 fired slugs matching the caliber of the pistol fire. Upon contact with the defendant, the law enforcement officer noticed the odor of alcoholic beverage and that the defendant was wet while fully clothed. The defendant stated he had
The defendant was what?
wet while fully clothed.
Wet while fully clothed, okay?
Sure. The defendant stated he had been drinking alcohol and smoking marijuana and that he fired the firearm in the apartment. The defendant stated he was wet because he dumped a bucket of water on himself. The defendant stated that he was paranoid at the time.
Mr. Kyles, I'm sending you for a drug test. I want to know what, if anything, is in your system. You're to come right back. I will appoint you a lawyer today, but you're not to use alcohol or illegal drugs. If I find that you're using, it's not going to go well for you. You're also not to be in possession of weapons. Do you understand? So, do you guys have a rip done on this case? Do we know whether she wants him back at home or no?
I made contact with the claimant, Your Honor, however, she did not wish to talk with me about the incident after.
She won't talk to you?
No, Your Honor.
Okay. Don't be in possession of weapons, Mr. Kyles. You know, I don't want to have to put you in jail and make.
Did you catch that? The judge is practically giving a survival manual. Keep the city safe. Don't pick up new cases. And don't test the limits of your bond, or you'll be stuck like Chuck behind bars.
Okay, so what we'll do is I'll appoint you a lawyer today. Or do you have the ability to hire a lawyer, or would you like a court-appointed lawyer?
You can appoint me a lawyer, and I may consider hiring one, but if I understand that it's not
I
understood.
just want to know whether you want a court-appointed lawyer or not.
Yes,
I
sir,
can
yes,
appoint
sir.
a lawyer today. I'm sending you for a drug test. I want to know what, if anything's in your system, come back, and then I'll have a lawyer waiting for you.
Okay.
Okay, please.
There's financial affidavit or no?
Hey, good morning, Judge. I'm here on Katrina Keys. You had her on docket for Friday for a bond violation, but she needed to come in and talk to you anyway, so she came today.
I'm sending you for a drug and alcohol test right now, man. But unacceptable, you're on bond for DWI, and you now have, you're allegedly consuming alcohol.
No.
Yeah,
I spoke with this Graham people and she said that was not it. It's not an alcohol violation. She doesn't know if
alcohol
my,
was detected during both tamper events. But they cannot be confirmed because of the nature of the tamper.
I haven't had a drink since I was arrested, Your Honor. I've done everything this court has asked me to, outside of looking for a job and everything. I have had no problems. I've called Graham about my device, because I have neuropathy swelling. Once it goes down, so she said it was loose. I asked them, the only thing that I did on Saturday and Sunday, which can be confirmed by my GPS monitor, I went to my son's basketball game. I left my house, went to my son's basketball game, from the game back.
Let's
I
do
have
this.
not done anything.
Lisa, do you mind sending me for a test right now, please? I'm gonna send you for a test. You
Okay.
come back. Do you understand?
Mhm.
We'll deal with the violation when you come back.
Okay.
Just please take a seat here. Tell me about it. No,
Oh,
she-
sorry, her drug test was presumptively negative, Judge.
ever test positive again, I'm going to keep you.
Judge was granted her.
If you ever tamper with the device again, I'm going to keep you. I'm doing everything in my power not to revoke your bond. Do you understand? I don't care what it is. If there's a problem with your device, you need to go have it switched out, go get it looked at, but I will not entertain any more excuses from you. No tolerance. Do you understand?
Yes.
Okay. All right.
Did she address my, curfew? My lawyer was supposed to ask you about my curfew because I got a job and I started today. And the job is from 5 p.m. to 6 a.m. at 8 a.m. And I have the letter saying that I've been accepted for the job.
She has something open elsewhere as well.
She needed open in Austin County, Your Honor.
Still open?
It's not still open. I'm sure she plugged it, or what happened was she looks like she's on probation now. For that one off.
You're on probation for DWI. You've not picked up another DWI. I don't want you driving in the middle of the night.
I'm not driving. I'm not driving.
That was just on March 26th, I think, Your Honor. There's no plug for when that case was resolved.
I'll resolve that case.
Still have an open DWI and you picked up another DWI.
I didn't. I haven't done anything since before.
Don't talk. All I know is that you have a probation for DWI, you have an open DWI. The last thing I want is another death on my streets. And I'm going to do everything in my... I tell Pete, everybody tells me what I want to hear here. And then when they get out there...
Before I took the job, I spoke with my lawyer. I have someone that works there and they shuttle and I can get a ride. But right now, like I'm having a problem with getting my lights turned off, the phone's turned off, I'm worried about monitoring, so I've been working very hard to find a job. This is the only job that I found and I need to work to survive, to pay my bills. I have to work. And with the background that I have, it's been hard for me to find a job regularly 8 to 5. This is the only thing that was available. And then I made sure that there was a ride or a shuttle. They work in shifts. So 5, 6 people in my neighborhood work there. So I've secured a ride to and from work.
Proof of employment, that you actually have a job working
I have
there.
it. My lawyer have it and I have the email right here.
With your lawyer, I want to see actual proof that you're working there. And then we'll put a GPS monitor on
I
your
have a monitor. I have GPS monitor.
exact address so that we know that you're going to and from work. If you deviate in the slightest, and I don't care what it is, that'll be your third bond violation, and I'm going to lock you up. I will deem you a public danger and make your bond sky high. Do you understand?
Yes.
Okay. Chief Mayor, I'll have you get with your lawyer and then they can get with pre-trial.
And I start today. It starts today at 5 p.m., which is why she had to come today.
Okay. I'll have you get with Ms. Reedy. She can get with pre-trial. You guys can work out the details.
All right, thanks.
Judge, would you like me to email that proof of employment to you or to pretrial?
No, to Felicia.
Okay.
I don't know if you have her email address. I'll see if I can get it for you.
Okay, please.
Give me a second. I'll chat to you.
Okay, thank you, Judge.
Good morning, Ms. Williams. Sir, you're charged with theft. You're facing up to a year in jail and a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Judge. On July 15, 2024, in Harris County, Texas, defendant was observed on surveillance video entering a pawn shop, accompanied by a female, a toddler, and a baby in a car seat carrier. The defendant was observed putting down the baby, picking up a projector, and concealing.
Oh, this one's bold, using a baby carrier to hide stolen goods. Talk about trying to weaponize innocence. But here's the thing. In court, a clever disguise is still just theft.
Was a sale. The defendant was identified by a Tennessee driver's license photo by the complaining witness. The value of the item stolen was $2,000 or $2,009.09.
Do we know if they got back?
I do not. Does not say in the DIMS. I mean, it's just my mom.
It's we can worry about it later.
Yes, sure.
Mr. Williams, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to go back to this pawn shop. You've also missed 3 different times. If you miss, excuses go in one ear, go out the other. Actions are what matter, Mr. Williams. You've missed court on 3 different occasions. If you miss again, I'm going to make your bond so high, it's going to hit the clouds. Do you understand? Do you have the ability to hire a lawyer? I'll have you fill out an application. I'll take a look to see whether you qualify. Okay, you get, every time you bond out, they give you paperwork telling you where you need to go, the date and time and the location. So I'm not going to argue with you, man. It's just, we've had 3 different occasions. Your case is 220 days old. So I'll have you fill out an application. I'm going to have you sign a receipt. I'm going to have you take a seat, but I need to do further bond conditions on them, so you're not allowed to leave until we do further bond conditions. Please, please.
We're approaching on Sean Williams. He's on today's docket.
This is the gentleman, it's a theft of the projector from, okay.
Victoria told me I needed to approach about bond conditions. But if you're happy with them all.
Well, no, the thing is, this case is super duper old, right?
Yes, and the judge, this was a 2B. And so that's part of the age. And then,
It's a true 2B for like 180 days, and I don't have a problem. But if he's been on bond, and then he takes off for 150, then.
so just my brief look at it, what looks like happened is it was a 2B. He got picked up, he paid an out-of-county bond. And his next court date was not clear to him. And
Come on.
so, he did bond forfeit. And then he paid another out-of-county bond and he's here today.
He's forfeited at least different times, now 212 days old.
It looks like to me, he's only bond forfeited once.
He's made.
And again, any amount of bond forfeiting is bad, but
Completely on this case. If you ever take off on me again, Mr. Williams, you know what's going to happen to the bond. And if you don't have anyone in this world that's willing to pony up 10,000, perhaps 5 to 10,000, you will be stuck like Chuck in there until this thing is over. Do you understand me? The only thing in this world I'm asking you to do is keep my county safe and show up. You pick up our case, you are unsafe to my county. It's really not going to go well for you. Do you understand me? I'd like you to do a writ first as well to see whether they got the projector back or not.
Yes, Your Honor.
And then,
Judge, if we can just have a regular reset,
your regular reset.
that way we can have a look at
And we
everything.
must be here at the next setting, so we're going to decide what we're going to do with this case. But I'm going to tell you now, if they didn't get it back, it will be part of anything that institution is. All right, Mr. Williams, don't have any contact with these people, don't have any weapons, don't pick up any new cases. So I guess the police will have you do it is just because it'll be faster so we can get them out of here. Just no contact with any witness, no going back to the pawn shop, no new cases. No drugs, no alcohol. Okay, all right, dude. Good luck. See you in 30 days.
Okay. Okay, so I have talked to pretrial in regards to the violations as to tampering with the scram.
You needed a translator anyway, right?
Yes,
Speak your mirrors.
yes. So, pretrial doesn't know exactly what was tampered with. He does work in construction, he wears boots, he wears socks, he does suffer from this condition called neuropathy, where he has to put like this cream on here. He says the scram actually has been causing him a lot of pain on his legs, so sometimes he shifts it to put the lotion and removes it. But since it was in the morning, he said it was probably like when he was at work with the boots. But there was no like EAC, no alcohol, nothing, it was just
Because they, a
tampering.
lot of times the way they do it, they tamper with it so that alcohol can't be detected. They'll put something in between the leg and the monitor to, evade. This is Enrique Ramirez.
This was,
A lot of times they'll say the tamper was from midnight to like 6 in the morning, so that we know that there was something in between the leg, or they've done something for that length of time. I don't know.
The first one,
And it says alcohol was
on
detected.
March 1st at 4:32 a.m., return to baseline at 2:40 p.m. That tamper was 10 hours and 8 minutes.
Come on up, Mr. Ramirez.
I don't see the second one, I see the one on the first.
Tenemos que estás, que tienes alcohol en tu sistema y que estás fallando con la máquina también. No, sir. La máquina me dice otra cosa. I don't know what to tell you, Mr. Solms, but
I mean, pretrial doesn't have knowledge as far as like what was the tampering. I mean,
they can't. It's impossible.
I know that, Judge.
All we know is that the device was not detecting the skin for a certain period of time, and at the same time, alcohol was detected.
¿Dónde estás el día primero y el día 8?
So let's do this. I'm gonna get a translator so I can properly translate and let him know what I'm gonna. Oh, Plaza. Can I borrow you for a second, please? I just need to help translate. Mr. Ramirez. You were instructed not to tamper or remove the device. We have 2 tamper events here, where on March 1st at 6:33 a.m. and the second one on March 10th of 2025 at 11 a.m. Alcohol was detected on the first event. Alcohol was not detected during the second tamper event. That's what I have. We need to do something with this case. It's 207 days old and he's now tampering with the device. So
I got it. I mean, we were ready for play today, but.
you're tampering with the device and you're consuming alcohol. Told you not to. Let's do this. I'll send him for a drug and alcohol test right now. And he'll.
Yeah, because he has no status. If he goes in custody, he will get a nice hold.
I have admonished you ad nauseum not to violate conditions, because if you go to jail, there will be serious consequences. And we now have tamper events and a positive alcohol rating. I am now going to send you for an alcohol and drug test right now. I want to know what, if anything, that you will test positive and you're to come right back. And we'll see.
Yeah, because he does say, he does use the creams on his arms and hands, so it doesn't have a BAC level or anything versus crimes, so.
Advise.
I understand, Judge, I understand.
All I know is that alcohol is detected and he's tampered with the device.
Okay, all right, Judge. All right, so I'll step out and then, okay, thank you.
What's up, man?
I'm here for Ricardo. He just said he just wanted to, Ricardo, for an admonishment, so.
Kim is here.
Oh, Dave's here. Okay. Hey, Dave, sorry, man, I've been in different courts.
Okay, I mean, if it's just for an admonishment, then I can just sit here. Like, if it was something contested, it'd be different, but it's just literally, it was the judge, it was the one we approached money for the remand, and it's just, I guess telling him about.
Do you want me to bring him out?
Yeah, let's bring him out. Can we bring out Mr. Joshua Sweat? Because I did want to talk about the reason why they're asking for an extension. And I talked to the client and I need to bring this up. Well, it's part of it, and I think you're saying that he's medically unfit to be transferred. I think that's the reason.
Right. So, I mean, in plain speak, he's detoxing, and medical needs to figure out when they're finished with that before Louisiana can even initiate the transfer. That's the issue. Is they can't even tell when they're coming because he's not cleared yet for transport. Ironically, so yeah.
So that's something that I want to address with client. Yeah, and sorry, I waited till the end on this, Judge, but I've been running around. It's one of those days.
Hey, we're all feeling. Don't worry about it. You're doing great. I'm tired too. I still gotta go fix a flat tire, man. That flat tire, come on.
Oh, no. Hey, Judge, you have AAA? You don't have AAA?
No, because you through your insurance, you have roadside assistance. Yeah. I forgot to call them. Hey.
How you doing, sir?
Are you Mr. Sweat?
Pretty good, how about yourself?
Well, let's talk. You know, I think that you, if I remember correctly, you have a parole violation out of
Louisiana, Judge.
Not Michigan, sir.
Or Michigan, sorry, Michigan. I'm sorry, I conflated two.
That's right, he was a Michigander, that's what we were saying.
Yes.
You know, a lot of times in life, you really have to read the fine print. You gotta read what you're signing. A lot of people just sign just because they're done with it. Yay, I'm getting on probation. Yay, I'm getting on parole. Let me just sign what I'm gonna do. You know, one of the things that you sign in the jurisdiction where you signed where you refuse, or I'm sorry, you waived extradition by signing the document that you agreed to be on. So whether you agreed to get on parole, whether you agreed to be on probation, you refused extradition by signing the document in and of itself. And then it says there, I will, you know, waive extradition if I ever become a fugitive from justice. You are now a fugitive from justice, meaning that you are wanted out of the state. So you can't sit here and say, you know what, I want to try to get a bond so I can just go turn myself in. You have already you have what's called a pre-signed waiver. You have already signed.
That's what I was trying to get back.
We are going to get you back. But the problem is that sometimes, you know, we give them up to 30 days for them to come get you from Michigan.
I was under the impression it's 14.
In the typical instance where I don't give someone a bond, yeah, but for pre-signed waiver cases, it's 30 days.
Judge, and if I may, that's my argument. When we did all this, we always talk about the practice of 14 days. And so when we originally talked, we reset it out 14 days, and we were all basing it on the 14 days. Now, the extension that they're seeking is my understanding because he is detoxing. And at that point, my question is, I talked to him when we talked about the 14 days. We understood each other. He understood me. He seemed fine. I talked to him again today. He seems fine.
But it may be fine now, but when he probably first got here and when everybody was notified, it may have been a different story. It may have been like, you know, just...
No, I talked to him when we talked about the waiver, Judge.
I'd been on my detox medication by the time I signed my waiver. I was no longer on even any detox medication.
And so my argument, Judge, I get it, and my argument is, hey, he's ready to go, we don't need extra time. Why are we holding him here extra days? Yeah, he signed the pre-signed waiver, but we talked about 14. If they're supposed to be here in 14, that's the practice, he's good to go.
That's not the practice of pre-signed waivers. It's not right. You know, the 14 days... And understand the 14 days, it's, hold on, the 14 days is us being nice because statutorily, it's 30 days. Even in the instance where if it were a 14-day thing where I'm going to get someone a bond, statutorily, it's 30 days. We do 14 days because we have so many damn people in jail that we try to get them out as quickly as possible. So as a courtesy to you, it's for everybody else, not for pre-signed waiver cases. It's we, as a courtesy, do 14 days. But in reality, we have 30, or they have 30 to come get you. And then Harris can release you at that time.
May I say one thing?
Sure.
Last, it would have been 8 days ago, last Tuesday, they they told me ATW. I went downstairs. They said Michigan is here to get you. I waited 4 hours and in a holding cell. Then they said, actually, they're not coming. I had to go all the way back through the booking process again. They took my money from my account, put it in a check. I cannot go to commissary, can't go to commissary. And the waiver that I did sign, I did read the fine print, and it said they have 14 days, and if they do not, 10 business days, 14 calendar days, and if not, then they can seek an extension if necessary. My argument, I understand everything you said, and I'm not questioning I know the law more than you, but I did read the fine print.
So hold on, let's find out. Mr. Kim,
Yes, Judge.
what's the good word? Tell me
So
about
they're supposed to be giving an update this afternoon. Hold on, I don't want to misspeak. Yes, I got an email about an hour ago, I want to say, that they should give the final update yesterday, but it's one where obviously they have to medically clear him. I mean, the liability alone in terms of, I'm not gonna just, trust that he's good to go until a medical professional tells me that he's good to go for transport. Because it's a liability on both, obviously, the sheriff's office side and Michigan side for the transport. We
You want to
have.
roll until tomorrow to see what they say?
Well, I mean, that's fine, but it's just for an update, just because, I mean, once the email comes in saying that it's clear, I would obviously relay that over to Ricardo. So, I mean, we can roll over, that's fine, but just rolling over isn't gonna rush the decision because they already have it on the forefront because we've been emailing about it.
Do you have any clue when they're gonna get here?
Well, so once he's cleared, they can book it. So I believe they said once they clear him, they can get him in.
What do you mean, once they clear him? What does that mean? He's not cleared as of right now?
That's what I mean. It's like right now, medical has not cleared for the Harris County side for Michigan to
I've
get
been on
him.
detox medication since the fourth
I have
day.
no idea what that means.
The fourth, when I was withdrawn because I take Xanax, and when I came in, they gave me a 5-day detox. I haven't been on detox
So
medication.
let's do this. Let's roll it to tomorrow. Who do I need to check in with to see if he clears from medical?
Well, I mean, it's the sheriff's office via Harris Health, but we're already in communication with them. That's what I'm saying. It's like no one's sleeping on this. We've been actively. There's like 40 emails this morning alone. No one is. They're just making sure he's cleared medically. And so there's no magic. It's going to be in 4 hours. It's when medical clears him. And it's not something that I can force, obviously, because it's determinative of his condition. Not just the fact that he's off medication. It's the equivalent of going into an ER. They have to observe, they have to make sure he's stable and he's safe for transport. I don't know what that means. And obviously the sheriff's office makes that determination based on safety. So safety of both him and the officers coming to pick him up.
I guess let's do this. Set it for Friday. And I'll reach out to the sheriff's office to see what the heck is going on so they can go interview him to get him cleared as soon as possible.
Okay, I will have this.
I will email now, figure out, sweat, right?
My understanding when I was until there is the prison that wants you Charles Elder reception, whatever it was. I think I mentioned it to you, who is just a lazy tether unit, but I think that's asking for you. But am I going to?
Mr. Day, I'm gonna CC you on this, okay?
Yes, Judge.
Give me a second. Hey, Ricardo, what's your email address?
Judge, it's R, last name Laredo.
832? Okay, I'm CCing you on this as well.
Judge, my only argument is, look, man, he looks in better health
No,
than I am.
that's why I'm emailing out.
Thank you, Judge, thank you, I appreciate it.
I'm, you know,
I actually have a court date set for the 16th, which would have been the day after my 14th day.
Okay. Well, Judge is doing, he's going above and beyond, I appreciate it out for us as well, so.
Thank you.
Let's allow him an opportunity to do so. So you can hear everybody's trying to figure this out. I mean, everybody sees you.
Yeah.
Judge sees you. I see you.
Yet he has been held in custody since when?
27th.
What is it?
27th of last month.
Is that right?
That sounds about right. I saw him.
Either, I don't want to take your word on it.
Dave, do you have that by chance?
It shows that he was filed on April 1st. Oh, wait, no, sorry, it's 3/31. So sorry, it's 3/31, yeah.
I was held in custody until the point from that
This is
27th.
not counting Pasadena.
Okay.
The point we're doing now is you look good. We're trying to make that happen as soon as possible. This is
They lost how many days? We lost. We're trying to figure it out.
Okay. So let's at least set you 2 days out to make sure, what my feeling is that medical's going to want to talk to you to make sure everything's fine so that you're fit for transport. Once that happens, they can get the fugitive prosecutor to let Michigan know, hey, come get him. And then hopefully they can do it within the allotted time. I've just set the email now. Let's set off for 2 days for Friday and we'll see. And hopefully that gets done.
Is the allotted time being 14?
I don't know yet.
Sure.
I don't know. I'm not going to commit to anything at this point because I don't know why they didn't clear you when they last interviewed you. So there's a lot of other things that play to determine when the day actually is. But be that as it may, we're going to try to get you out as quick as possible.
Yes, sir.
No one's sleeping on it. No one's waiting for just